thank you for coming today to do this talk. Really appreciate it. Katie and I have done a lot of work over the years. Wilkin Chapman and Fortis do a lot of work together, so it's been great that you've agreed to come along.
Thank you.
Hand over to you. Just got to press the start button, Katie. Keep an eye on you.
So can I just check the clicker? Oh, it is working. Thank you. I don't know why I've got my slides. Okay. Hello, everybody. I'm quite loud, so you should all be able to hear me. So my name, as Alexis said, is Katie Davies. I'm a partner in the employment department at Wilkin Chapman, and I also head up the education sector at Wilkin Chapman. So 80% of my working week is dealing with educational establishments, so I feel your pains. I speak to you a lot. There's lots of my clients in here in the room today, and also some new faces, which is great. So I've only got 30 minutes, that's all Alexis would give me. So I'm going to do a bit of a whistle-stop tour. So I'm going to cover some of the legislation that's already come into effect, some things that are on the horizon, and then I'm going to finish off with what we might expect if the Labour government get in. Now, I know the manifesto's come out today. Unfortunately, even though I've got 6 o'clock to sort the kids out, I haven't had a chance to digest it all yet, but I don't think it's fundamentally going to change what we think is going to happen. Obviously, we can give you a bit of an update once we've had time to delve into this manifesto, and we'll probably send a newsletter around explaining what we think is going to happen. But obviously, these slides were prepared a couple of days ago before that came out. So, holiday pay, oh no, what a nightmare. We all hate holiday pay. I normally hand it over to Lily because it's just a complete nightmare. It's too complicated. Holiday's meant to be nice, it's meant to be a nice thing, yet we have holiday law, which is just a complete nightmare, and no one really understands it. So we've had years of concrete uncertainty, lots of case law, very complicated, no one knows what's to pay. So what the government has done is tried to make it easier for us. So they've introduced some new legislation, most of which has come into effect, which is meant to really, put simply, clarify all the case law, where we're at, bring it all together. So I'm only going to go over some key points, because if we were talking about holiday pay, we could be here for hours. But these are the key things which I think are going to make life, hopefully, a bit easier. So we've got some new definitions in relation to irregular hours workers, part-year workers. They're the ones that cause us all the problems. Those people have those weird and wonderful contracts. Atypical workers are a nightmare, cause lots of problems, particularly in relation to holiday pay. So we've got some new definitions of what that means. We've got a new definition of what normal remuneration means. So back to basics, you may know 5.6 weeks holiday. I know it's prorated, but that's the basic principle. 4 weeks is under EU law, and 1.6 weeks is under UK law. So we have this weird situation where 4 weeks can be calculated at normal remuneration, and the 1.6 weeks under UK law can be calculated at basic pay. So you could, in theory, do 2 different calculations for your different periods of holiday leave. I have to say that's a complete nightmare and probably costs you too much money and hassle to work it out. But it's worth an exercise of looking at how much the difference would be, because under EU law for the first 4 weeks, you have to pay normal remuneration, which is more. So that includes anything which is intrinsically linked to the performance of the role. So what that means in plain English, bonuses, commission, allowances, any weird and wonderful extra payments that people get, which they would get if they normally worked. So bonuses, it doesn't mean a bonus which you as the employer give to everybody just because you've had a good year or, you know, everybody's done well. It means a bonus which is linked to their work that they'd normally get if they worked, an allowance which is linked to their work. So that's what the law has said now. So because we've had so much case law about bonuses, commissions, but actually, if somebody would normally get a bonus or commission if they're at work, because of their work, they should receive it. Overtime, it's been clarified that you have to pay overtime in the holiday pay if it's regularly worked in the preceding 52 weeks. So, a client the other day said to me, well, I have this department and they work overtime, but it might be 1 hour a month, it might be 10 hours a month. I said, well, do they normally work some overtime, be it 1 or 10 hours? They said yes. I said, that has to be accounted for. It doesn't matter how much it is because you work the average over 52 weeks. If there's an expectation that person works overtime, you have to now include it in holiday pay for at least the first 4 weeks, okay? So that is the law as it stands. We've also got some new legislation in relation to carrying forward holiday pay. You probably all know that you have to carry forward in relation to maternity, you know, family-friendly stuff, and sick leave. You also have to allow it where you as the employer haven't given a reasonable opportunity to take it. So it doesn't mean you have to force everybody to go on holiday. It doesn't mean you have to go, you take your holiday now. What it means is if you don't allow them to, they can carry it forward. So top tip at Wilkin Chapman, what we do, our holiday year runs April to April, we will probably in, say, February have an automated HR system that sends a reminder to everybody saying, you have this many days left. If you do not take them, you lose them. So we have given employees a reasonable opportunity. If they don't take it, they lose it. But if you don't do things like that, they will lose it. They will be able to carry it forward. We've also got 2 new things which may have come into effect. They come into effect for your holiday year after the 1st of April. So if your holiday year is January to December, this yet is not law, okay? And this is clarifying the Harbour Trust case and all those ridiculous decisions about part-year workers, irregular workers. We now have law that says you can pay rolled up holiday pay. I know you've all probably been doing it anyway. But legally, you can do this if you separate it out in the payslip and it's clearly shown as separate pay for holiday. You can pay it legally for holiday years after the 1st of April. So I've had lots of clients saying to me, well, my holiday year isn't until January, what should I do? Well, you've been paying rolled up holiday pay for the last 10 years. Why are you going to change it now? But at least then we know it's legal. And reversing the decision of Harbour Trust, they now only accrue holidays based on 12.07%. So you may recall that that ridiculous decision of Harbour Trust said that you had to pay the music teacher, wasn't it, at school, you had to pay them the same holiday based on 5.6 weeks, even though they only worked during term time. That's been reversed, and therefore you pay holiday based on 12.07% of the hours that they work. Now, I could talk about a lot more, but that's just keeping it really simple. TUPE. So TUPE always seems to be a bit complicated. Everyone gets bogged down in it. But as we know, the simple position of TUPE is if you've got a conversion you're taking in a school, the employees will transfer under TUPE. If you've got a cleaning contract or a catering contract and you're taking it in-house and you're then doing that contract, the employees will transfer to you under TUPE, okay? We've got some changes which are coming into effect for transfers on or after the 1st of July. So not yet law, but coming into effect from the 1st of July onwards, because you may know that you have an obligation to inform and consult under TUPE. At the moment, there's an exemption that says you don't have to appoint employee reps, so you still have to inform and consult, but you don't have to appoint employee reps and go through all that hassle of doing the ballots, which is just tedious and pointless, where your business, your employer, is less than 10 employees. This is going to change that and extend the exemption, so it's a good thing. So you won't have to appoint employee reps if you have a business which is less than 50 employees, or it doesn't matter how big you are, the transfer affects less than 10. So if you have a cleaning contract and you're taking it in-house and there's only 8 employees, for example, after this you'll be able to inform and consult with them direct. You won't have to go to that hassle of appointing employee reps. If they've got trade unions and you have to consult with them, that is different. It doesn't change that. But if you have a commercial contract, like a cleaning contract, who don't have trade union, under a collective agreement or something, then you will be able to consult with the individuals direct. It just makes it a lot easier. People want to be spoken to direct. They don't have to go to the hassle of appointing employee reps. So that's sensible. Right, I'm just going to cover equality, discrimination, harassment in a nutshell, because this is really a hot topic. We're getting loads of harassment cases at the moment because I think all these celebrity harassment cases have really brought it to the forefront. There's some new legislation I'm going to talk about, but we are getting a lot of them. I think more than we've ever had, haven't we, Lily? Yeah. So equality, we've got some changes here. None of this is substantial, and all it's really doing is preserving the existing position because we've left the EU. This is just preserving it now under UK law. So equal pay claims, we don't get many of those, but basically it's clarifying the law which says that an individual doesn't have to compare themselves with somebody in the same employer. There has to be a single body responsible if there's an inequality, but it doesn't necessarily have to be the same employer. Now, I wouldn't worry about that. We get very little cases about equal pay, and it's only going to be relevant if you have an entity that works over lots of connected businesses. If you work at Wilkin Chapman and you're trying to bring an equal pay against someone at Bridge McFarlane, that is not going to work. It's not like that. It's still got to be a single body. So we've got a new definition of disability. This is ridiculous. As we all know, and I always say, the definition of disability is so low, anybody can argue they're disabled. We're probably all in here feeling disabled at one point with stress and anxiety. So the government decided it wasn't low enough and they needed to lower it a bit more. So we've got a new definition of day-to-day activities. So under the definition, the individual has to show that it's impacted on their day-to-day activities. So now that has been changed and that has now got wider to include more day-to-day activities. I seriously wouldn't worry because it's not going to mean you get more claims. People always say they're disabled anyway, and the threshold is so low in any event, I don't think it's going to change anything. Quite sensibly, we've got confirmation that it's direct discriminatory to discriminate against someone who's breastfeeding. You would have expected that. Also, we've got some new protections for people returning to work, but that's all quite sensible and really just codifying the existing position about what is direct discrimination. We've got a new right in relation to discriminatory statements during recruitment. So somebody can bring a claim if there's been a discriminatory statement in an advert or some kind of recruitment exercise, and there isn't even somebody hasn't been appointed, and there isn't even a victim. You don't need those for someone to say that that statement is discriminatory. It is enough in itself for them to feel discriminated by it, even though somebody hasn't been appointed or somebody hasn't been discriminated against. It's just to show that you can't put stuff out there that's discriminatory, as you would expect. The biggest one on here is in relation to indirect discrimination. We don't get lots of those claims, and they're quite complicated. But basically, this is making it quite wide for individuals. The individual now can bring a claim and they don't have to share the protected characteristic with the disadvantaged group. What that means is, I could say, Joe Bloggs, I've been indirectly discriminated against by that practice because I think it's indirectly discriminatory, because the people who have been disadvantaged, who've been discriminated against, are those people. I don't have to share the protected characteristic with them. So I can be, basically, I can say I'm aggrieved, discriminated against by that practice that has affected somebody else, and I don't have to share the protected characteristic. So that is extending indirect. It's so complicated, I have to say, who is actually going to know that? So I wouldn't, again, over-worry any of this. It's just a bit more technical, and it's clarifying some of the case law we've seen. But I wanted to concentrate on philosophical belief and bullying. So philosophical beliefs is one of the protected characteristics that somebody can bring a claim for. We are seeing a major surge in this area because it is the category where people try and shoehorn themselves in. The leading case here is the case of Granger, and this was Mr. Nicholson who said, I have a philosophical belief because I believe in climate change. You've discriminated against me. So the whole case of Granger was about whether he had a philosophical belief. It held that he did, and it laid down what we call the Granger test, which is the 5-stage test. This case of Verstater applies that test. So the 5-stage Granger test says to have a philosophical belief, you have to have an honest belief, which is genuinely held, has to be weighty and substantial, has to have a sufficient level of seriousness. So it has to be serious, not a joke. And it has to be worthy of respect in a democratic society. So you can't just go, I've got a philosophical belief because I'm a vegetarian. That isn't a philosophical belief. But you could say, I've got a philosophical belief, I'm a vegan, it runs through me, it's how I live. That could be a philosophical belief if it satisfies the test. The reason why Verstater is important is we have this competing issue where the employer, by protecting one belief, is discriminated against another. So in this case, the lady was gender critical. She believed there was only 2 genders. She said quite derogatory things on social media about transgender people, calling somebody a part-time cross-dresser and a man in heels. So they were her beliefs. Now, she had those beliefs, but she shouldn't have put them on social media and said those things. People were offended by those, okay, quite rightly, raised it with, she was a worker actually, she wasn't an employee, but raised it with the company, and they ended her engagement, okay? She said she had a philosophical belief, she was gender critical, that was her belief, and that she'd been discriminated against. So they had to establish in this case whether she did have a philosophical belief, applying the Granger test. And the EAT, because it went all the way to the big courts, said she did. It said whether or not her beliefs were capable of offending you, that didn't matter. If they satisfied the Granger test, worthy of respect in a democratic society, etc., they were capable. And because there'd been some kind of academics writing books about this, and she had something that supported it to show it had a sufficient level of seriousness, it wasn't just a joke, she won and she was awarded £105,000. And we've had 2 cases since, probably more now, that have relied on Verstater to argue that they have philosophical beliefs, gender critical and stuff. And I actually think in that instance, the business thought they were doing the right thing. Offensive comments were made on social media against one protected characteristic group. Somebody said to me the other day, what would you have done? Well, obviously, I'd have done it different and would have won, obviously. However, I feel really sorry for the business. The only thing I can say is I'd have probably warned her, reminded her of the social media policy. I don't know how tight the social media policy was, said this is not acceptable. And then if she did it again, then end, because then you're ending it because of the conduct, if that makes sense. But I think that was really unfortunate. Moving on to bullying. So again, this is now leading on to harassment. So this case concerned a guy of Indian origin, Alian Gayland, So he was dismissed for poor performance, nothing to do with it, but did the classic, oh, well, I'll now bring a race discrimination claim. Now, he was, in my opinion, racially discriminated against. Comments were made to him such as, well, you drive a Mercedes like other Indians, and why don't you work in a corner shop like other Indians? So clearly not acceptable, right? However, the case here is about the employer being liable. So individuals had said that. But why was the employer liable? He argued the employer was liable because they hadn't protected him. They hadn't taken reasonable steps to protect him. The managers knew, he told them, people observed the behaviour, nothing was done. They argued, it's not our fault. We've got training in place and we have policies. And they lost because the court held that the training was stale and the policies weren't fit for purpose. The training had been 18 months before this. Now, I actually don't think that's that bad. And we were surprised by this because normally if somebody said to me, oh, the training's about 2 years, 18 months, I'd probably say, we'll do a bit of a refresher, but I wouldn't think that was stale. But the guidance was every 12 months. So when you've got your code of conduct, your harassment policies, all to do with your ESG, anything that's like that, you need to be reviewing your policies. Obviously, Wilkin Chapman can assist you with that. You need to be getting your training done because this is a top area because of all the ESG stuff. This leads on to now, shows you the way the government's going because we've got a new harassment protection which is taking it even further. This isn't yet law, it's coming into law on the 26th of October. There is a positive duty to take reasonable steps to prevent harassment, but this is only sexual harassment, okay? Probably going to come in for other harassment, but this is only sexual harassment. So an employer has a positive duty. It is a claim. So in Ellie, they were arguing that, like, well, our defence is we've taken reasonable steps. This is the other way now, it's going further. We haven't really got any guidance of what those steps are going to be, apart from it's got to be practical, proportionate and tailored. Tailored to your business. It's the usual, the bigger you are, the more's expected of you. I hate saying that. I was speaking to a client last night, big client, and I'm saying you're a bigger client, more's expected of you. If you're a smaller client, you can get away with more. I know that's wrong, but that's just the way it is, okay? So it's not a claim in itself, it's brought along with a sexual harassment claim. And if you haven't done this, the individual gets increased compensation by up to 25%. So it's going to be worth a lot. And obviously, because it's going to be in the news a lot, we're probably going to get another surge of harassment because it'll be a top topic for people. Just going to turn to some family-friendly rights that we've got in, some new extensions. And again, this is showing you the way the government is going. We're giving more flexibility, more protection for people who look after people, carers, etc. We've got some changes to paternity law. This isn't major. It's not extra. All it is doing is adding flexibility. So previously, somebody had to take a block of 2 weeks paternity. Now they can take it in separate blocks. So it's just giving a bit of flexibility for the person taking the paternity leave. And they used to have to take it in the first 8 weeks. Now they've got up to the first year of the child's birth to take the paternity. So again, not costing you more, just giving more flexibility to the individual taking it. Flexible working. How many times do we get contacted about these? We've seen a surge in this, in flexible workings, because of the new law, because it is now a day one right. As you probably know, before you needed to have 26 weeks continuous service. Now it is a day one right. So I got one the other day from somebody who'd been there 3 months. So normally they let themselves settle in a bit before they throw the flexible working. That's gone. So straight in there, and then the employer did the classic, oh, it's a full-time job, Katie. It's got to be a full-time job. There is nothing, can I just go back to basics? You are never going to win at court if you say it's a full-time job. Even head teachers. There has been cases where flexible working for head teachers have been refused because they've said it's a full-time. That isn't going to wash. Now, when I mean that, there's very difference between being full-time and part-time is if somebody's doing 2 days a week as a head teacher or somebody's doing 4 days and, 4 hours. So it's got to work for you as the school, the entity, but there is no such thing as a full-time role, okay? Part-time is someone who works 99.9% of the hours. That's still part-time. So if you get a flexible working request, don't just reject it and say it's full-time. Go back with a compromise, even if this sounds really mean, even if it's a compromise that isn't going to work for them, doesn't matter, it is a compromise, okay? But the law is changing it, so day one right, and they can put 2 in now rather than 1 in the first 12 months, okay? So we're just getting more of them because more people, and they keep trying it on again because they can do 2. Redundancy, this is what we call Regulation 10, that's what I always call it, I don't know if you know it by that name. So this is again extended the right. So before the law came into effect, somebody on maternity leave had the right to positive discrimination. They had the right to get the job over above somebody else on mat leave because of Regulation 10. So if you had 2 people doing the same job and you needed to reduce it to 1, if somebody was on maternity leave, they had to get the job, even if they weren't the best candidate. This positively discriminated against that person. The government thought, oh no, that's not far enough, we want to extend it, so it has, and this is law. So this extends Regulation 10 to when somebody tells you they're pregnant all the way during that period, and all 12 months maternity and up to 6 months after. So all that period, if you have a situation there that there's a redundancy, that person has the right to the job over and above anybody else. Now, if you are abolishing the role completely, they don't have the right because there is no role. But if you reduce in numbers, they have to get the job. You can't interview them and do their skill set. They have the right. So I used to have clients who were delaying, before this change, I used to have clients who were delaying doing redundancies until somebody came back from mat leave. Now, they're not doing that. They're having, they're having to wait even longer. I know I'm on time, aren't I? Sorry. Carers leave, this is So carers leave, this is a day one right, another day one right. So you can see we're moving towards that direction, which is what Labour want to do as well, which I'll talk about in a second. This isn't going to cost you anything. It's unpaid, and it's only the right to 1 week. So I can't imagine for a minute you're going to get this a lot. You're probably just get people not turning up or going on holiday rather than doing this because it's unpaid. So what have we got to watch? So apparently this is on every slide for the last 3 years and it's still not law. So the government keeps saying they're going to do it, but they haven't yet. Apparently it's when parliamentary time will allow. When will that be, especially with the election? But they are proposing to make non-compete clauses which are longer than 3 months void. So any contract you have, if it's got more than 3 months, for the non-compete, not the other restrictions, you can still go longer for those, but for the non-compete, it's going to be void. It's against, free movement. The government hate it. So clients keep saying to me, should we review our covenants? Should we change them? And I keep saying, well, I wouldn't yet because we don't know what they're going to do. When parliamentary time allows could mean another 3 years, or never if Labour get in. We don't know. Maybe they'll change it again. I wouldn't do anything. Have to say, you shouldn't be having longer than 6 months anyway for somebody who's very senior. The general position should be 3 months because if they're longer, they'll be void. So if you've got somebody who's senior, 6 months is probably okay. General employees, 3 months is average. So you probably just need to review them anyway and get them, if you're reviewing your contracts at one point, really focus on your restricted covenants, but you don't need to take any action at this time. So we've got this random, it's a bit like a right to make a flexible working request, but we've got this right to request more predictable hours. Again, it's a right to request. So you don't have to allow it, it's only a right. What you do if you get one is follow a process similar to the flexible working request process, consider it and determine whether you can allow it or not. And what it means is the individual wants to request more certain hours, basically. They want to, rather than being on these weird and wonderful irregular hours, it's the right for the worker to say, I want this change to have more certainty and I want it to take effect on this date. You as the employer, if you get that request, have to review it and decide whether you can do it or not. This isn't yet law. It's due to come into effect September, October. We haven't got a definite date yet, and maybe we'll get more guidance. ACAS actually has a guidance on this on their website, and there are requirements for continuous service on this one, not like the flexible working request. It's not a day one right. They have to have performed some work in the preceding 26 weeks, okay? I can't imagine we're going to see a lot of this. But again, if you get it, make sure you deal with it appropriately, even if you reject it, and one of the business reasons why, because otherwise you could have a claim for not following the procedures. We've had some quite good new guidance on menopause on the European Rights website. So this was published in February. Now, we're getting loads of cases about menopause. Again, it's another hot topic. To me, it should be something that employers are supporting anyway, so I don't know why it's a new thing, because menopause has always been there. I don't get it. However, the key thing I wanted to say is, and this, as a woman, I'm saying this, so it sounds like I'm being negative now, it isn't a new right. This legislation, this guidance, is just clarifying what your duties are under the Equality Act and what you should be doing to help people. It's about helping and supporting people. It's not rocket science, okay? But this isn't a new right, and menopause is not a disability in itself. That has been held under case law. However, menopause can cause lots of things, and me and Alexis know all about this. Sorry, I'm being quite personal, Alexis. It can cause lots of... It can cause lots of weird and wonderful things, and they in themselves could be disabilities. So menopause itself isn't, but the things it causes can be, okay? But all this is doing is giving practical steps and tips about what you should be doing anyway. But I'd hope you'd all support your employees if they were going through a bit of a difficult time anyway. But it isn't a new right, okay? So you shouldn't be worrying thinking, oh my God, is menopause a disability? It isn't, but the things it causes may be. Last slide, Julie. So, what are Labour going to do? What is going to happen? Well, again, like I said, I apologise, I haven't yet digested the manifesto, so it may go further than this, it may have been watered down. We all probably watched last night's performance on Sky News in Grimsby, so apparently Labour were now 63% even more likely to get in. So anyway, what they are going to do, I think, is abolish lots of these weird and wonderful practices. They plan to abolish 0 hours contracts. They don't like all these irregular contracts which don't provide any certainty. People can't get mortgages. They don't know how much they're going to earn a month. So that is definitely on the agenda in this document. They're also going to extend the time period for bringing claims from 3 months to 6 months.
No,
Oh, was you just in despair there, Lily? You're just thinking more claims? I don't, well, but do you actually think that? I don't know if it will, because to be fair, people are normally quite on it. They do ACAS early conciliation. You normally know within the first 3 months if someone's going to try it on. So I don't know how much that will make a difference. I don't know. We are potentially going to have more day one rights, but as you can see from what I've been talking about, we're kind of getting a theme of more day one rights anyway. They're talking about potentially an unfair dismissal or something similar day one right, but then they talk about a probationary period, so we don't know. But we're likely to get more protections early on, more rights for individuals, more certainty. They're on about delivering a genuine living wage, so higher than national minimum wage. So again, people are going to be paid essentially more. We don't know what that's going to look like. And potentially going to introduce a single status. So rather than having these weird and wonderful categories like worker, employee, self-employed, which create loads of problems of status and loads of issues for lawyers, they're just going to have one status of a worker, which basically they get all the rights, which part of me thinks, God, that means more rights, but part of me thinks at least there's clarity about what somebody is, because how many times do clients phone me up and I have to spend half an hour determining if they're a worker or an employee and what they are, because then we can determine how to proceed with them. So you'll see ending hire and fire. So that's that practice where, and I do this all the time, sorry, when clients phone me up, I go, how long have they been there? Are there any discrimination issues? If not, you can do what you want within reason. Sounds really mean. Obviously, I say it a lot better than that, but that's essentially what I'm saying. They're going to stop all this hire and fire where the employer has the power to basically threaten people with, if you don't accept it, you'll be dismissed. Because what they're saying is, they entered into that contract, you're now trying to change it, that's your problem, not their problem. They entered into that in good faith. But you can see the general theme. It's going to keep us really busy and we're going to get loads more work. It's not probably good for you guys. I don't think they're going to go quite as far as we probably expected. I think they're trying to be a bit more medium, because obviously they don't want to put voters off. But obviously when they get in power, if they do, probably likely, watch this space. Anyway, if you want any help, I'm here today. Obviously, we've got Lily, who's also here, who works in employment. Becca, who's one of our trainees at the moment. We've got Kelsey in commercial. I know a lot of you anyway. Obviously, if you want to get our details, Alexis can send them on. And yes, we do. Oh, that's us. That's the education team. So thank you very much.